Hey, everybody. Switching it up a little bit. I got to sit down for this. I got to sit down for this. I'm going to share some powerful information with y'all. I'm going to read. I'm going to do some explaining as we go through this. All right, this is facts, a very powerful facts. It was successfully sent. And reference ID, Justin Hall case, number of pages 28. And so we'll get into this here. This is, let's see. This AMICUS CURIAE is available for download on the services page of my website, oralhealthwithcannabis.com. You can find the address in the description box. Also on my Telegram channel, my main Telegram, my chat channel, it is pinned as well as posted. On the PBI Telegram channel, the main PBI Telegram channel, it is posted and pinned. Now, people, this is for your education. This is for you to own your authority. This is for you to know the power you have and the fact that for the first time, probably, well, the court's been around for a little bit. So this court is the first court we the people have had, probably in my lifetime. How's that? So this is really, really, really something here. So I may stumble on a few of these words. Some of them may be a little hard for me to pronounce since I'm not that familiar with them. And then some of this, I'm not gonna say if it's in quote marks, if it's in brackets, and yada yada yada, because it's all there for you to go and download and have for your own to read. All right, have for your own to study from. So, in the New York Western District Court, Buffalo, New York, Robert H. Jackson Courthouse, 2 Niagara Square, Buffalo, New York, 14202. It's got the phone number, it's got the fax number. United States District Court versus Justin Andrew Hall regarding plaintiffs against Justin Andrew Hall, defendant in error. Brief of the clerk of the Environmental District Court as Amicus Curiae. Amicus Curiae, I believe, means friend of the court. All right, back to reading. In support of general welfare of the people of the United States, and more specifically, the man, Justin Andrew Hall de jure. All right, and then we have Environmental Court Tribunal listed here, number 951 JTC, 949 MJ, 954 JX, a couple more there. Constitutional Tribunal for Amicus Curiae. And then there's another address down here for 1901 Ranch Road, 1431, Suite 1514, Kingsland, Texas, state, zip exempt. It's got the phone number, it's got the email. All right, that's page 1 of 10. There's 28 pages here. All right. There's going to be a lot of reading, but it's very educational, very powerful. See, they didn't teach us how to handle our affairs, handle our business, own our authority. But we're here to teach you. We are. Statement of compliance with Supreme Court Rule 37.4. Pursuant to Rule 37.4, the consent of the parties to file this brief is not required. Under Federal Rules of Evidence, Rule 201, a friend of the court files this brief with attachments and beliefs irreparable harm to defendant could cease upon its filing. Question presented. Do fraud upon the state, fraud upon the court, fraud upon the judge, and fraud upon the officers of the court affect a court's standing to prosecute a matter? All right, now there's a footnote here for, it's got a number 12. I think I have to go a few pages forward to find footnote 12, which I'd be happy to read if I find it, when I find it. I'm not coming across it right now, but anyways, I'll just get back to this. Interest of AMICUS CURIAE. A lot of pollen in the air. Man, it's just blowing like clouds. Excuse me. Interest of AMICUS CURIAE. The people of the United States of America and the people of New York, respectively, the state, have a strong interest in protecting their constitutional rights. Got to exercise the lungs. All right. The constitutional right of specific interest of the AMICUS CURIAE is the people's constitutional right to life, liberty, and property absent due process of law, without which standing and jurisdiction over a fellow citizen cannot be achieved. All right, we have footnote 3 here. So footnote 3. A fellow citizen is a joint tenant of sovereignty of the United States of America, as confirmed by the Supreme Court of the United States, and further stated in the Declaration of Independence to be the only citizenship of the new United States for America, as defined in the Word of God in Ephesians 2:19-22. All right, that's footnote 3. So back up to the reading. The clerks of the court are the people's last line of defense. Our duty of care requires us to assure all prongs of our guaranteed right that the people's God-given rights, as defined under Article 5 of the Bill of Rights Amendment, that the people's right to life, liberty, and property shall not be trespassed upon absent due process of law. Therein lies the duty of the clerk of the court to acquire jurisdiction. One first must have standing before the court. It is the duty of the clerk to confirm the plaintiffs have standing before the court prior filing the case onto the court docket. This is some really powerful stuff. I just smiling ear to ear as I was reading this first time through. It is the duty of the clerk to confirm by affidavit of the injured party, describing the injury in fact, or by physical evidence that property was damaged prior to a case number and file being created. The elements of lawful jurisdiction in a matter must be met prior to the clerk of the court allowing the case to be filed. to allow any case brought against one of the people of the United States of America, absent due process of law, being proven with evidence, would be a gross breach of duty. All right, that's 2 of 10, but there's 28 pages here because there are attachments or exhibits or additional. Apologize for not having that language, but you're with me. All right, we'll keep going. Let's see. Did I ended in the middle of a sentence, so let's go back, but I picked that up. Would be a gross breach of duty, malfeasance of office, and because you have taken an oath to office, the unlawful act would also be a violation of your oath. An act of treason as defined under Constitution, Article 3, Section 3, a felonious contempt of court. The additional constitutional right of specific interest of the amicus curiae is the people's constitutional right to fair proceedings overseen by a judge of good behavior, lawfully ordained under constitutional judicial power by the people through their Secretary of State pursuant to the Constitution for the United States of America, 1789, and provide proof and evidence that said judge and officers of the court is not disqualified from acting as a judge in any court of the United States pursuant to full faith and credit rule, California Constitution, Article 6, 18A, and is a breach of U.S. Constitution, Article 3, Section 1, requiring a good behavior, and is in fact disqualified to act as a judge of any court of the United States due to information that he is daily committing violations punishable as felonies under federal law, and more specifically is operating in daily violation of law of the land, public law 92-586, stat 816, October 18th, 1972, Section 2, and Sections 301, 306, and 307 at a minimum. Yeah. That's what they're doing. They're committing these felonies daily. They have no standing. None. Oh, this is so good. All right, we'll keep reading here. Introduction. It is now a well-known truth that the district courts of the United States are insolvent and operating without bonds, which is a municipal hazard, breach of the public trust, and a direct liability to the people they oathed to promote the general welfare of the people of the United States, as contemplated in the preamble of the Constitution for the United States of America, 1789, as evidenced will show the defendants are all operating in violation of Public Law 92-500, Federal Water Pollution Control Act, amendments of 1972, Section 2, Section 301, 306, and 307 at every point source of discharge of toxic pollutants, poisons, owned and or operated by above defined judges and officers of the court and all other responsible corporate officers at minimum. It has been further adjudged by the Supreme Pontiff Francisco in his apostle letter of July 11th, 2013. All corporations and their responsible corporate officers are members of a criminal enterprise operating in association with the Roman Curia and are since September 1st, 2013, personally liable for their wrongs. This includes their unlawful toxic discharge violations since July 1st, 1973, constituting acts of gross negligence in the nature of mass genocide against the people of the United States for the last 48 plus years. This fact alone viterates all standing of adversaries, so-called judges and officers of the court in the United States District Court, actions against the fellow citizen and man, Justin-Andrew Hall. And there's a footnote 5 there. Footnote 5. The same feudal, I believe that's how you pronounce it, feudal ideas run through all their jurisprudence and constantly remind us of the distinction between the prince and the subject. No such ideas obtain here at the Revolution. The sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects and have none to govern but themselves. I think this goes on. I believe this goes on. Yeah, it does, but it skips to the next page. And have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in sovereignty. And then it's this cites a court case here, Chisholm versus Georgia, 2 U.S. 419, 417, 1793. All right, so move on to the next page. See if my cigarette's still burning. Okay, let's see. We got some comments here. Says, you just fired them all. It is all administrative actions. That's how they circumvent our rights protected by the constitutions. Yes, indeed. Yes, indeed. All right, we'll keep reading here. United States, relation Justin-Andrew Hall, a fellow citizen, challenged to prove due process of law and accordingly subject matter jurisdiction. Uniform universal notice and demand for discovery and inspection of evidence. Challenge juris of United States District Court and standing of judges and officers. Federal Rules of Criminal Procedure, and that's FRCP. Rule 16, Discovery and Inspection. Federal Rules of Civil Procedure, Rule 60B3. FRCP, Rule 26 and 37 of Title V. FRCP Rule 17A1 and Public Law 92-500, Federal Water Pollution Control Act, amendments of 1972. Fellow citizen as defined in the Holy Bible, Ephesians 2:19, and International Covenant on Civil and Political Rights, Part 1, Article 1, Clause 1. See also Civil RICO, 18 U.S.C. 1964, False Claims Act, 31 U.S.C. 3792, and International Admiralty Maritime Law codified under Title 33, Chapter 26, 1319, C, 3A, and D. The people of the United States of America in this court of record proceeding according to the common law moves the state court, including all officers of the state court and all other interested persons, to take mandatory judicial notice of this notice of bill and notice and demand for discovery and inspection of evidence and challenge of jurisdiction of this court and standing of its judges, magistrate, judges, its officers, and all other interested persons in answer to the following points on and for official public record, to wit. Hey, Josh Eddy. Good to see you here, brother. To wit, comes now one of the people, the United States of America, G. Juris, a real party in interest, hereinafter the people of the United States of America, regarding the above styled and numbered cause, having standing of the people of the United States of America as ordained in the Holy Bible, Genesis 1:26, further confirmed in the preamble of the Constitution for the United States of America, 1789, and pursuant to instant injury caused by deprivation of liberty as a result of false claims to cause the unlawful trespass upon tenant of the sovereignty. All right, got that page done. I gotta help the pipes out here. All right. Court may not proceed. However late this objection has been made or may be made in any cause in this district court of the United States, it must be considered and decided before any court can move one further step in the cause, as any movement is necessarily the exercise of jurisdiction. Jurisdiction is the power to hear and determine the subject matter in controversy between parties to a suit, to adjudicate or exercise any judicial power over them. The question is whether on the case before a court their action is judicial or extrajudicial, with or without authority of law, to render a judgment or decree upon the rights of one of the people. If the law confers the power to render a judgment or decree, then the court has jurisdiction. What shall be adjudged or decreed between the parties, and with which is the right of the case, is judicial action. By hearing and determining it, jurisdiction is essential to give validity to the determination of a court or administrative agencies, and where jurisdictional requirements are not satisfied, the action of the court or administrative agency is a nullity. Where a court has jurisdiction, it has a right to decide every question which occurs in the cause, and whether its discretion be correct or otherwise, its judgment, until reversed, is regarded as binding in every court. But if it acts without authority, its judgments and orders are regarded as nullities. They are not voidable, but simply void, and for no bar to recovery sought even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. No officer can acquire jurisdiction by deciding he has it. The officer, whether judicial or ministerial, decides his own peril. Every jurisdiction has its own bounds. Subjects matter, jurisdiction, and cause shall be determined from the answers to the elements of discovery as defined in paragraphs 2 through 14 herein. Jurisdiction of the person and of the subject matter is not alone conclusive, and jurisdiction of the court to make or render the order judgment depends upon due observance of the constitutional rights of the accused. Jurisdiction cannot be assumed by the court, nor conferred by agreement of parties, but it is incumbent upon the accuser to allege in clear terms the necessary facts showing jurisdiction, which must be proved by convincing evidence. Jurisdiction, once challenged, cannot be assumed. It must be decided, clearly shown, and proved to exist. Spike Life, welcome. We suffer a lack of knowledge. Bring the wisdom, brother. I'm working on it. Oh, and I tell you, the great one just keeps on providing, just keeps on downloading. And he had a hand in this. We can be assured of that. All right. Here we go. Therefore, the people of the United States of America move above captioned adversaries to each provide discovery for inspection of each of the following items required to acquire standing in this matter. The people of the United States of America hereby admits into the court of public record as evidence in its entirety this notice of bill and notice of demand for discovery and inspection of evidence to challenge juris of the court and standing of the judges and its officers necessarily in regard to these matters and causes and prove their constitutional judicial standing required of a court, officers of the court or administrative agency, and prove its judge is, the S is in brackets, are entitled to hold their office during good behavior and are not disqualified due to felonious misbehavior before the court can proceed one step further, as all proceedings must stop upon a challenge of a court's jurisdiction to hear a case and upon a challenge of officers of the court to prosecute a case. No sanction can be imposed absent proof of standing to achieve jurisdiction. This is official public notice of bill to the court of public record and all officers of the United States District Court. All right, that takes care of page 5. A little more coffee with my poison water. My toxic water. Yep. All right. This is continuing on. So, get back to this. This is official public notice of bill to the court of public record and all officers of the United States District Court, including, but not limited to, the Honorable Chief Judge Elizabeth A. Wolford, District Judge Lawrence J. Villarado, and U.S. Magistrate Judge Mark Peterson of said court, and each individual employed with this military tribunal operating as District Court Administrator, District Prosecuting Attorney, Deputy Prosecuting Attorney, Clerk of the Court Mary C. Lewinguth, as well as any other judge, attorney, pro temp, notary, court reporter, magistrate, commissioner, bailiff, witness, police officer, sheriff, grand jurors, herein collectively responsible corporate officers of the United States District Court, and the Honorable Mayor Byron Brown of the City of Buffalo Municipal Jurisdiction located within the County of Niagara County Judicial District, at a minimum, all the adversaries as defined above, all witnesses to include all departments of justice, drug enforcement, and FBI officers, and all other responsible corporate officers that wish to preside or involve themselves in this matter, and more specifically to include, but not limited to, all parties to this action, collectively adversaries. All right. Josh got a reverse osmosis. Now you need a distiller. All right. We'll keep reading here. The people of the United States of America here in this court of record, proceeding according to the federal common law and having competent and final jurisdiction in this matter, hereby moves the above captioned court by notice and demand for discovery and inspection of evidence to challenge jurists of the United States District Court and standing of judges and its officers, to command the officers and United States District Court persons and all persons involved in this matter to answer each of the hereunder elements of discovery required for inspection to prove jurisdiction of the above entitled court and standing of the above defined adversaries of the clerk of the court, Mary C. Lewingith, she's got a tough name to pronounce, shall within 10 days of the date of this amicus curiae brief is delivered, receive the answers to discovery from each of the above defined adversaries claiming a right or interest in regard to the herein defined matter. And clerk of the court, Mary C. Lewingith, shall submit said answers to discovery from the adversaries to the clerk of the environmental district court via United States Postal Service, priority mail, care of above address. Alternatively, upon the failure of adversaries to provide each of their individual answers to discovery to the clerk within 10 days, clerk of the court, Mary C. Lewingith, shall submit a statement of default on behalf of each adversary to be entered upon the record in this matter, and a clerk certified copy emailed to address above. Each answer shall address each of the elements of discovery necessary to prove jurisdiction of the United States. You catching this, people? This is powerful. This is your court. This court was enacted by the 92nd or 93rd Congress, I think 1972. That'll get written. I believe that's in the readings here. District Court and standing of its officers to charge and prosecute the elements demanded for discovery and inspection are delineated in paragraphs 2 through 14. To wit, number 2, provide true and correct copies of originals of any and all affidavits lawfully executed by injured party, defining the persons and or property injured, confession, declaration, testimony, video, audio, documents, papers, books, accounts, certifications, letters, photographs, registrations, objects, or tangible things not privileged, which constitute or contain evidence material to any matter involved in this action, and which are the possession, custody, or control of the attorneys, witnesses, the district court, or any of its officers, agencies, agents, political subdivisions, or interstate agencies thereof, attached and signed under penalty of perjury on and for the official public record. Provided all names of any witnesses for the number 3. Provide all names of any witness for the United States District Court that shall be summoned to testify against the man, Justin Andrew Hall, for deposition, attached and signed under private notary jurat, under penalty of perjury, on and for the official public record. Number 4. Boy, I got an itch going on. Provide a true and complete copy of the original alleged contract having all 8 elements of a lawful contract, having the wet ink signatures of all parties to the contract between the man Justin Andrew Hall and the United States District Court or any political subdivision thereof may have. Law confirms that in order for above identified adversaries to have standing to bring a claim against the man Justin Andrew Hall, there must be either an injured party, damaged property, or a valid contract having all 8 elements of a lawful contract to qualify standing. If the adversaries or any state or political subdivision thereof has a valid lawful contract between the man Justin Hall, showing the man Justin Andrew Hall, and the man showing the man, Justin Andrew Hall, knowingly and willingly, without threat or duress, surrendered his Constitutional Bill of Rights Amendment, Article 6, unalienable and ordained right to life, liberty, and property, absent due process of law, that the man, Justin Andrew Hall, knowingly, with full disclosure, surrendered subject matter and personal jurisdiction to adversaries, or that adversaries are employed in receiving emolument from one of the adversaries, corporations, and is therefore subject to that corporation's codes, rules, or ordinances. Let them bring it forward for the man, Justin Andrew Hall, to inspect, attached, and signed under private notary jurat, under penalty of perjury, to prove good faith standing on and for the official public record. 5, provide proof of the man, Justin Andrew Hall, intent to commit a criminal act. Provide proof that the man, Justin Andrew Hall, is not a fellow citizen of God's people and a tenant of the sovereignty of the United States of America, as confirmed at law in Chisholm versus Georgia 2 U.S. 419, 471, 1793. Provide a true and complete certified copy of each of the above defined adversaries' oaths of office as required for public service, commissions by the Secretary of State authorizing each of the above defined adversaries' constitutional judicial authority, as well as the name of the state. Municipal and county insurance. Municipal and county insurance carriers, and the bonds of all officers of the United States District Court, including but not limited to the deputies, bailiffs, court clerks, judges, magistrates, pro tems, commissioners, attorneys of the record, and any and all that may decide to involve themselves in this matter, appointed or elected, signed under private notary jurat, under penalty of perjury, to prove good faith standing on for the official public record. Provide true and correct copy. This would be 8. Provide true and correct copies of the adversaries, employee's pay stub, and the sewer and water bill or septic system permit issued for their workplaces, and each of the adversaries' private residential residences for the last 3 months, attached and signed under private notary jurat, under penalty of perjury, on and for official public record. 9, provide a true copy of the certificate of constitutional authority signed and sealed by the Secretary of State for all judges, magistrates, commissioners, pro temps, attorneys, and all officers of the United States District Court involved in this matter, signed under private notary jurat, under penalty of perjury, to prove lawful standing to bring charges and to prosecute tenant of the sovereignty on and for the official public record. 10, provide a true certified copy of the Public Law 92-500, Section 2 and Section 401, certificate of compliance for each source of pollution owned or operated by above defined adversary, signed and sealed by the Director of the State Department of Public Health, proving adversaries lawful compliance with federal effluent standards and limitations congressionally mandated, proving adversaries' compliance with Sections 301, 306, 307, and said federal law of the land, to prove adversaries are operating in compliance with federal laws of the United States, mandated by the 92nd United States Congress, assembled on October 18th, 1972. I told you I'd be reading it. I had that all about right, but there it is. All right, we'll keep on reading. Adopted and codified under International Admiralty Maritime Juris, Title 33 U.S.C. 1251, ET, SEQ, signed under private notary jurat under penalty of perjury to prove compliance with mandatory environmental law and good faith standing on and for the official public record. You guys got to share this. And you got to share it. You're not going to just share it. You got to speak up and say something about it. This is what they've been hiding from us. This is what they stole from us. This is what they've been doing to us. Now it's boom time. Boom time. Own your authority, people. Number 11. Provide a true certified copy of adversaries' records of best available technology performance mandated under Section 308, identified by brand name, the congressionally mandated best available technology currently serving their homes and workplaces, sources of man-made, man-induced pollution, in compliance with mandatory standards and limitations established under International Admiralty Maritime Law, Title 33, Chapter 26, Sections 1311, 1316, and 1317, and a permit condition under Section 1342, A, B, and K to evidence each of the adversaries' good faith, good behavior compliance with strict liability environmental laws, International Admiralty Maritime, and federal public health and welfare laws, signed under private notary jurat under penalty of perjury to prove good faith standing on and for official public record. Provide certified copies of the, number 12, provide certified copies of the attorneys of record appearance form having their license to practice signed and sealed by Secretary of State, attached and signed under private notary jurat under penalty of perjury to prove good faith standing on and for the official public record. Now, these treasonous rats, like dirty, evil, treasonous rats, and they can't get away with it anymore if you want to own your authority. So because they wanted to go and arrest one of our process servers, we're moving forward against them. And we, the people, are coming at you, all you evil tyrants that are poisoning us, murdering us, mass genocide, enslaving us, trafficking us. 13, provide all CUSIP numbers tied to this matter on and for official public record. Provide a W-9 for each of the adversaries of this action to include the judges and attorneys authorized to practice law in the United States District Court. 14, provide the foreign agents' registration certificates as federally required under the Foreign Agents Registration Act of 1938, as amended for all officers of the court and members of the bar, signed and sealed by United States Secretary of State, proving the United States District Court and each officer of the United States District Court are foreign agents lawfully registered to do business in courts of the United States as defined under Title 28 U.S. Code 451 and required under Title 18 U.S. Code 219 on and for the official public record. And then we go to Roman numeral 2, so that's moving to another part of this. The failure of each of the adversaries to answer each element of this demand for discovery delineated in paragraphs 2 through 14 would, in dishonor, 1, be a gross breach of duty owed the man Justin Andrew Hall, a malfeasance of office proving actual misprison of felonies, and would at a minimum warrant tort actions against each of the adversaries, and 2, confirms United States District Court's absolute lack of jurisdiction and confirms the adversary's absolute lack of standing to charge or prosecute anyone the Trezevant versus City of Tampa, 741 F.2D336, standard at law, relief of $65,000 per day of unlawful apprehension, detention, detainment shall apply. Additionally, the insurance companies holding each of the responsible corporate officers' liability insurance policies will be liable for $1 million per adversary, to include all agent corporations, their responsible corporate officers, upon each of the adversary's failure to answer. The adversary shall give advance notice to their liability insurance providers of the potential upcoming liability and demand for settlement within 72 hours. Their failure will justify their being additionally joined to this action. Wherefore, premises considered, and in the interest of fairness and justice, the man, Justin Andrew Hall, reminds the above captioned court of the well-known standing at law decided in the matter of Louisville Railroad versus Motley, 211 U.S. 149 29 S. Period, CT period 42, that premised, if any tribunal finds absence of proof of jurisdiction over person or subject matter, the case must be dismissed, and all charges, adjudications, and decrees against tenants of sovereignty, such as the man Justin Andrew Hall, are void. Nunc pro tunc ab inito, for lack of due process of law as guaranteed, the tenant of the sovereignty and the man Justin Andrew Hall shall be set free to go. Take due process notice. Upon the court's failure to discharge this matter for lack of standing and proceed, Justin Andrew Hall gives advance notice of intent to remove this case to a proper district court having original and final jurisdiction in the matters in regard to a federal question of jurisdiction and possible counteraction. All right. Environmental District Court finding. The Environmental District Court, pursuant to additional material evidence hereto attached and incorporated in its entirety as Addendum A, introduces additional material evidence at this late stage of the above entitled proceeding pursuant to Federal Rules of Evidence, Rule 201D, delivers this amicus curiae complete with Addendum A to the clerk of the court, Mary C. Lewinthirth, so as to enter onto the record material evidence of facts and truth that is specific to the standing of the above defined United States District Court, Western District Court of New York, case number 22 CR 86 LGV, that may affect the ruling of a qualified judge as opposed to not having such information. If there is no qualified judge, court has no standing to proceed. Conclusion. The people of the United States respectfully call for the United States District Court, the clerk of the county, Mary C. Lewinthirth, in the interest of swift justice, find in favor of the above entitled man, Justin Andrew Hall, justified by but only one factor. There are no questions going to the merits presented in the amicus curiae brief that presents unquestionable merits to prove plaintiff's United States District Court, Western District of New York's lack of constitutional authority, and its judges and all the officers of the court have an absolute lack of constitutional standing. Nunc pro tunc, to bring charges against the man, Justin Andrew Hall, a real party in interest, injured in fact as arising under Federal Rules of Civil Procedure, Rule 17, and additionally pursuant to Penhallow versus Downs whatever, 3 U.S. 54, 1795. Their judgments are void. The man Justin Andrew Hall shall be set free to go. So be it. The court, on this 14th day, the month of June, in the year of 2022, it's got seal of the court, clerk of the court, Marcia Hobson, seal of the court, seal of the clerk. And that's the end of page 10. Wow. Now, we get into Addendum A. And Addendum A, well, this is I believe this would be a delayed Moab. That's what it looks like to me here. Ex parte petition uniform writ. So you see what I will go through here is our writs, the environmental court's writs that we, the people, are serving on these tyrants. And they're scared. Yep. We've got a lot going on. We got a lot going on. These tyrants are scared. So somebody put the word out into the Postal Service, into the Postal Office, and, oh, we got more treason, would appear. Blatant. So we'll be bringing it to them. We're going to get this straightened out. We're going to get this all straightened out. And people, this is how you own your authority. They're going to take and pick up one of us. It's got to end. See, this is what's going to start happening at some point. One of these road pirates, one of these child traffickers, see, you're all children of God. Doesn't matter what your age is, they're trafficking is what they're doing in these administrative places they call courts. They're just a corporation with a corporate name. They can call it anything they want. They call it a court. It ain't no court. It's just more fraud. That's all it is. And they're trafficking us. And this road piracy, all this trafficking, it's got to stop. And it should be at the simplest level. You're driving down the highway, you people. You're driving down the road, the lane, the parkway, whatever it is. And you see a road pirate's got somebody pulled over. They got those emergency lights going. What emergency? They created the emergency, didn't they? They got to have an emergency to turn those lights on. And there they are, trespassing upon a fellow citizen. Well, it's your duty. It's your responsibility to do something about it. And everybody ought to just hit the brakes. Hit the brakes and surround that road pirate, that treasonous rat, that communist parasite, and take him into custody and deliver him to go before a tribunal because he's already been convicted. 6 felonies a day. Minimum. Repeat, habitual offender. Poisoning you. Poisoning all of us. There's a lot of reading here. There's a lot of reading here, but I'll get through some more of it. Maybe I'll get through all of it without going to part 2. Part 2 video. We'll see. Got any questions? go ahead and put them in the chat there. I'll do my best to answer them. Addendum A, material evidence of fact and truth. Cover letter, elected officials and responsible corporate officers. Ex parte petition, uniform writ of execution. Elected official resolution, uniform writ of execution, elected official, uniform writ of execution, bar member, material evidence of crimes committed. Right on, Josh. Thank you. All right, so this is cover letter. Elected official and responsible corporate officer. The people being the last line of defense to our unalienable rights and the protections of our land, air, and water have been forced to take a stand and provide new guards, as the Declaration of Independence makes clear is our duty. The PBI is one of many new guards. The PBI, that's the People's Bureau of Investigation. You are an elected official and a responsible corporate officer. You have been convicted of multiple crimes against humanity by a high court of the land and the sea, and on the sea. You have been convicted by the Environmental Court, a court created by an act of Congress assembled October 18th, 1972, and commissioned of, for, and by the people in 2013. Please see the attached writ of execution and a resolution by an elected official that must be signed and returned in order for the tribunal to consider any measure of leniency regarding sentencing for your crimes against humanity. Your current position as a responsible corporate officer of a corporation makes you an enemy of the people by default. You are knowingly or unknowingly engaged in overt acts of war and warring against the people. Neither you or the de facto system that you represent have jurisdiction or standing at law. Your so-called jurisdiction was founded on fraud. Our government has been occupied by foreign agents of the bar, enemies of the people, now for over 200 years. The bar attempted to hide this knowledge from the people and failed. America currently has approximately 175 bar attorneys in the U.S. Congress. Bar attorneys are British accredited registered agents, often referred to as esquires. An esquire is a title of nobility. They are also referred to as bank authorized representatives. Bar agents are beholden to the Crown Court Bar. The Crown Court. Bar agents currently operating within all levels of government shall be abrogated. Bar agents consistently come against the Judiciary Act of 1789 that was reaffirmed in 1948 under USC 1654. The people have a right to represent themselves. The people were supposed to be educated regarding their rights in common law. The bar eliminated what should have been common knowledge. Bar agents have unlawfully monopolized and weaponized the unlawful legal system against the people. According to the original Article 13 in the Bill of Rights, anyone with a title of nobility, an esquire, bar attorney, cannot operate within our governments. The War of 1812 involved book burning and an attempt to eliminate and hide Article 13. The United States Constitution Title of Nobility Clause makes it clear that agents of the bar are enemy of the people. Bill of Rights, Article 13. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall without consent of Congress accept and retain any present pension, office, or emolument of any kind, whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. U.S. Constitution, Article 1, Section 9, Clause 8, no title of nobility shall be granted by the United States, and no person holding any office for profit or trust under them shall, without consent of the Congress, accept any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. The republic was largely taken over, sidelined, and sacrificed by the corporate rulers by way of esquires. The people of the republic will no longer allow persons with title and nobility to operate within our government. The law and our founding documents speak for themselves. The republic is alive and well. Your ignorance of the law regarding your responsibility to provide people with clean tap water is inexcusable. You must sign a resolution by an elected official and return the original to the processing center. You must get your affairs in order and be prepared to plead for mercy before the tribunal. Sincerely, one of the people. All right. Now, Environmental District Court. For the Environmental District Court of the United States, Authority, People versus Fauci, ETAL, case number ENC 20210813. This is ex parte petition 4, uniform writ of execution, notice of criminal conviction, demand for settlement of penalties, citizen's arrest, no warrant required. And this is something that our servers, which can be you can do this. You put the tyrant's information in here, the registered mail number up here, and over at the PBI Telegram channel is where you learn about this. You go over there and read the welcome post. The link to the PBI Telegram channel is in the description of this video. The address, the web address for the People's Bureau of Investigation, the PBI, is in the description of this video. You can go to the website, go to the documents page, download these writs. There's 4. There's one for elected responsible corporate officers, appointed responsible corporate officers, bar members, attorneys, judges, and organizations. You choose the appropriate one. There are literally millions that need to be served. So go after the worst of them. Go after the ones in your county. Own your authority, people. This is how you do it. And when they go after one of us, what I just read to you, that's what you do. That's how you own your authority. All right. This ex parte petition by fellow citizens of the United States of America who suffer imminent instant personal injury caused by unlawful discharge of chemical and biological warfare agents by the United States corporations, their states and political subdivisions, and interstate bodies for failure to adopt and enforce the strictest standards of effluent limitations and unlawful acts since July 1st, 1973, pursuant to 1365F, causing breaches of the peace, breaches of duty of care under international law, and acts injurious to human health as defined under 1342K, and death. The felony violations by responsible corporate officers are overt acts of crimes against humanity, public health and general welfare, International Admiralty Maritime Law, Title 33, 1251, ETSEQ. Lawful cause of action is provided under Section 1365F. Arrestable offenses for persons provided under 1319. Now, these are additional counts that can be checked. So if you're dealing with the sheriff, you're dealing with the mayor, you're dealing with anybody that was dealing with Jabberdewy, GMOs, 5G. You can put another felony count on them. You just check the box. And so I'm going to skip reading over that one just because this is YouTube. We'll go on to this one. Unlawful discharge of pollutants in the form of radiological warfare agents as defined under 1311F into human body of living water is an unlawful act committed by above responsible corporate officers in violation of criminal violations as defined under 1319C3A and is subject to this writ of execution 4. And you can put down another count. Criminal violation of unlawful discharge of warfare agents into a human body of water. GMO, glyphosate, canola oil, constitute an unlawful discharge of toxic pollutants in the form of chemical and biological warfare agents as defined under into a human body of living water is an unlawful act committed by above responsible corporate officers in violation of 1311A is a criminal violation as defined under 1319C3A and is subject to this writ of execution 4. And you can put the count in. Count of criminal violation, unlawful discharge of warfare agents into a human's food supply. Not even the president can exempt compliance with sections 1316 and 1317 as affirmed under section 1323. The below defined unlawful acts have been unlawfully occurring since July 1st, 1973. The above defined responsible corporate officer is charged criminal penalties as provided under 1316 C3A for each of the following. 2 counts of criminal violation for unlawful discharge of chemical and biological warfare agents, section 13A and 1311F. 1 count at the address above and 1 count at their individual home source of discharge. 2 counts of criminal violation of national standard of performance to eliminate discharges, section 1316A, 1316E. 1 count at address above and 1 count at their individual home of discharge. 2 counts of criminal violation for prohibition, affluent standards, and pre-treatment standards, section 1317B and 1317D. 1 count at an address above and 1 count at their individual home source of discharge. Point of law, your silence is acceptance as Q non neget. Fatitur, your admission to all claims against you. Silence equates to your agreement, your consent. What to do, provided in the instructions. Important notice, read carefully. On September 27, 2013, a 25-member independent grand jury A 25-member independent grand jury of the people returned a unanimous true bill indictment against all responsible corporate officers who were convicted of criminal felony violations of strict liability of environmental laws defined under Title 33 U.S.C. 1319 C3A, to wit, Title 33 U.S.C. 1319 C, criminal penalties. 3, knowingly endangerment. A, general rule, any person who knowingly violates Section 1311, 1316, 1317 of this title, and who knows at the time that he hereby places another person in imminent danger of death or serious bodily injury shall upon conviction be subject to a fine of not more than $250,000 or imprisonment of not more than 15 years or both. The class and category for persons criminally liable is responsible corporate officers, to wit, Title 33 U.S.C. 1319 C, criminal penalties. 6, responsible corporate officers as persons. For the purpose of this subsection, the term person means, in addition to the definition contained in section 1362(5) of this title, any responsible corporate officer. All crimes are defined as crimes against humanity, war crimes, genocide, and traitorous treason committed by the above defined responsible corporate officer who is acting and operating with knowing intent to murder the people by toxic pollution, poisoning of water, body, mind, soul, and spirit. Felony conviction disqualifies any person from holding public office. All benefits shall be stopped. These crimes justify a criminal penalty of $250,000 and for 15 years in prison per violation in international, military, and constitutional law. Overt acts of treason call for the penalty of death. Excuse me. If the resolution to adopt and enforce environmental law, Public Law 92-500, Federal Water Pollution Control Act amendments of 1972, ratified by Act of Congress, assembled on October 18, 1972, Section 2, Federal Water Pollution Control Act, Sections 301, 33 U.S.C. 1311, 306, 33 U.S.C. 1316, and 307, 33 U.S.C. 1317, has not been received by the Arrest Reward Processing Center, care of P.O. Box 1514, Kingsland, Texas, 17639, within 30 days of registered mail receipt, the environmental court shall proceed to issue an order to arrest and to seize of all assets and real estates of the above defined responsible corporate officer operating at the above defined address and within the above defined federal zone. In the interest of enforcement as provided for under Article 13 of the Articles of Confederation, the court shall further authorize the Uniformed Citizens Arrest Award of $10,000 per person and $20,000 per member of the bar associations operating in government corporations as responsible corporate officers as defined under Section 309, 33 U.S.C. 1319C, criminal penalties. This court shall authorize the arrest reward be paid upon presentment of the booking documents payable to any citizen or citizens without warrant. Section 311, 33 U.S.C. 1321, M. 312, 33 U.S.C. 1322, I. Payable to any citizen or citizens without warrant. Uniformed Citizens Arrest Authority to be decreed by the court. Any person may arrest without warrant anyone who is or whom he, without reasonable cause, suspects to be in the act of committing an arrestable offense. And where an arrestable offense has been committed, any person may arrest without warrant anyone who is or whom he, with reasonable cause, suspects to be guilty of the offense. And a person may use such force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders or of persons unlawfully discharging pollutants. And arrest without warrant other person. A person other than constable may arrest without warrant. A. Anyone who is in the act of committing an indictable offense. Anyone whom he has reasonable grounds for suspecting to be committing an indictable offense. And where an indictable offense has been committed, a person other than a constable may arrest without warrant. A. Anyone who is guilty of the offense. B, anyone who he has reasonable grounds for suspecting to be guilty of it. Uniformed citizens' arrest to be ordered by the court. The preamble of the Constitution ordains the authority and the Articles of Confederation for the United States of America. Article 13 authorized the common treasury to cover all cost of enforcements of law. Title 33 U.S.C. 1365 confirms all citizens of all citizenships are authorized to administer suits and enforcement of environmental law. Environmental law is the law of the people to be complied with by all responsible corporate officers, and even more so, those responsible corporate officers operating in government positions of authority. The court shall authorize the arrest reward to be paid upon the arresting citizen or citizen's presentment of documents confirming the successful booking of the convicts to the Arrest Reward Processing Center address, care of P.O. Box 1514, Kingsland, Texas 78639, by the people of the United States of America. Original Arrest Reward Processing Center, petitioner copy, responsible corporate officer copy. So there's 3 copies that you're going to do. You serve copy to the tyrant. You keep copy. Original copy goes to the Arrest Reward Processing Center. All right. I'll take a break from the reading for just a minute. Have another sip of coffee with my toxic water. I don't have a reverse osmosis. I don't have a water distiller. And thanks to a couple of supporters, the lights are on for another 30 days. The website's up for another 30 days. On the website, oralhealthwithcannabis.com, you can go download this document on the services page in the documents section. You'll find it. Learn to do this stuff for yourself, people. They didn't teach you this. We're teaching you. We're teaching you. See if we got any questions. All right, no questions yet. Hour and 17 minutes into this so far. I think I can get through this. All right. Now, this is another document. This is page 1 of 4. The United States of America. Notice by elected official. Notice to principal is notice to agent. Notice to agent is notice to principal. A resolution by an elected official. To all persons, let it be known by these presents that, and this is where the treasonous rat would put in some information. And then, according to my duty of an elected official, herein after a responsible corporate officer, hereby by my hand and seal do resolve to adopt and enforce to wit. You see, they'll all get a chance to go before a tribunal of 3 and plead for mercy. Yeah, that's what they're going to get if they sign the resolution. If they don't sign the resolution, there's no pleading going to get them anywhere. It's lights out. That on July 11th, 2013, the people of the United States of America, Republic, as defined in the Articles of Confederation of A.D. 1777, the first union and source of all powers, and as contemplated in the preamble of the Organic Constitution for the United States of America, and Supreme Law of the Land, Article 6, gave notice to all members of the Roman Curia, aka Deep State, of the commissioning of the Environmental Court, a high court independent and separate from, without, the courts of the United States. The Environmental Court is a court of record, proceeding according to federal and international common law. The Environmental Court was commissioned by the people pursuant to the law of necessity in answer to the Apostle Letter of July 11, 2013, issued motu proprio of the Supreme Pontiff Francis on the jurisdiction of judicial authorities of Vatican City State in criminal matters involving persons deemed members, officials, and personnel of various organs of the Roman Curia and institutes and members connected to it. The Environmental Court is a transitional high court authority having original and final jurisdiction over all environmental matters, constituting heinous crimes of violation and war crimes being committed against the people, acts of genocide and environmental terrorism, secretly, unlawfully discharging listed and unlisted chemical and biological and radiological warfare agents by poisoned weapons of mass destruction, said being operated by corporate members of said Roman Curia, transitional criminal organizations committing environmental crimes against the body sovereigns and their God-ordained liberty, the people's unalienable rights to clean water, clean food, clean air, clean governments, and clean earth. The Environmental Court was established by two-thirds majority vote by the 92nd Congress to override the President Richard Nixon veto, October 18, 1972, Section 2, 7, and 9 of Public Law 92-500. Federal Water Pollution Control Act Amendment of 1972, 86 Stat. 816, and in accordance with the congressional mandates in the preamble to the Constitution for the United States of America and its original 13 articles, ratified March 10, A.D. 1819, of the Bill of Rights Amendment and pursuant to the supreme power of American nationals, respectfully, the people, to wit. The people have rights retained which were not made available to their government authorities, of whom all powers originate from the people. Article 9. The powers not delegated to the United States government by the Constitution, nor prohibited by it to the states, are reserved to the states respectfully or to the people. Article 10. Turn the page. Be it resolved, pursuant to the powers of the people retained and fellow citizens, unalienable God-given liberties and authority pursuant to God's word, Genesis 1:26 and Matthew 5:33, affirmed by Public Law 97-280 and the Constitution of the United States of America, A.D. 1887, Article 3, and by all citizens of all citizenships are authorized to serve the writs of Environmental Court, Federal Rules of Civil Procedure, Rule 4.1, and as further authorized under 33 U.S.C. 1365. It is further resolved that the responsible corporate officer shall assist the citizens of all citizenships in the service of all environmental district court writs. The person of responsible corporate officer acknowledges the environmental district court shall prosecute crimes against humanity, transitional offenses committed against nature's law, the international law of nations, the international law of the duty of care, and the rule of law. The International Environmental Court shall order, adjudicate, and decree justice upon offenders, egregious obstructions in the administration of environmental justice, and who are knowingly operating in violation of congressional mandates of Public Law 92-500, Federal Water Pollution Control Act Amendments of 1972, Section 2, Federal Water Pollution Control Act, and more specifically as codified under the family of International Admiralty Maritime Law, Title 33, 1319, enforcement, and as provided under 1365, citizen suits. It is further resolved that the non-discretionary duties of the person of responsible corporate officer include to execute and return the processes and orders of any court established by act of Congress assembled and of officers of competent authority to include private attorney generals, marshals of the environmental court, and their deputies, and to assist same in the execution of writs of the environmental court as authorized under Title 28, 1651. To exercise the same duties, powers, and arrest authority within municipalities with which such officers exercises in the unincorporated areas of counties, pursuant to the duty of responsible corporate officers, shall assist the Environmental Marshal Service to execute all lawful writs, process, and orders issued under the authorities of Constitution for the United States of America, and shall commend any necessary assistance to execute its duties. A proclamation of constitutional public health and welfare crisis justifying a national and international emergency. Emergency resolution to adopt, promulgate, and enforce uniform water quality standards of Public Law 92-500, Federal Water Pollution Control Act, amendments of 1972. In accordance with the mandatory requirements of the Constitution for the United States of America, 1787, as contemplated in the preamble of the Constitution to promote the general welfare of the people of the United States of America, and further pursuant to the law of the land as authorized pursuant to Article 6 of said Constitution for the United States of America, and further strict liability statutes as ratified by the 92nd United States Congress assembled October 18th, 1972, Public Law 92-500, Federal Water Pollution Control Amendments of 1972, 86 Stat 816, October 18th, 1972, codified under the International Admiralty Maritime Law, Title 33, Navigation and Navigable Waters, Chapter 26, Water Pollution Prevention and Control, Section 1251, Congressional Declarations of Goals and Policy, and further as authorized pursuant to Title 42, Chapter 103, Subchapter, I think that's I, maybe one, I think it's I, 9605, National Contingency Plan, and pursuant to my duty to humanity and in the interest of public health and welfare of the American people, do hereby jointly execute this resolution to adopt, promulgate, and enforce the most strict water quality standards as mandated, and for the emergency preservation of our multimedia resources such as, but not limited to, states' waters, water quality, and aquatic life, and for the mitigation of unlawful human organ toxic pollutant discharges, uniform water quality standard. Witnessed, whereas responsible corporate officer pursuant to the herein defined authority granted them pursuant to their oaths to the Constitution and the duties of the responsible corporate officers do hereby commit to adopt and enforce and herein defined uniform water quality standards pursuant to the duties of my authority as congressionally mandated by Congress assembled, United States Code Title 33, Chapter 26, 1370, that states, 1370, state authority, except as expressly provided in this chapter. Nothing in this chapter shall, 1, preclude or deny the right of any state or political subdivision thereof or interstate agency to adopt or enforce any standard or limitation respecting discharges of pollutants, or B, any requirement respecting control, or abatement of pollution, except that an effluent limitation or other limitation, effluent standard, prohibition, pre-treatment standard, or standard of performance is in effect under this chapter. Such state or political subdivisions or interstate agency may not adopt or enforce any effluent limitation or other limitation, effluent standard, prohibition, pre-treatment standard, or standard of performance which is less stringent than the effluent limitations or other limitation, effluent standard, prohibition, pre-treatment standard, or standard of performance under this chapter, or 2, be construed as impairing or in any manner affecting any right or jurisdiction of states with respect to the waters, including boundary waters, as such states. And whereas responsible corporate officer, effective July 1st, 1973, under United States Code, Title 33, Chapter 26, 1365, F, acknowledges and resolves they have a non-discretionary strict liability and duty of care under such authority and right to adopt and enforce the most strict effluent standard or effluent limitations respecting discharges of multimedia pollutants, and to adopt and enforce any requirement respecting control and abatement of all state source pollution throughout the environmental district of the United States, and most specifically the above defined county within the above defined state within the United States. And whereas responsible corporate officer declares it an unlawful act under subsection A of United States Code Title 33, Section 26, 1370, for any state or political subdivision thereof or interstate agency to not adopt and enforce any standard of limitation respecting discharge of pollutants. And whereas responsible corporate officer declares it an unlawful act for any state or political subdivision thereon or interstate agency to not adopt and enforce the most strict effluent limitations or other limitations under United States Code Title 33, Chapter 26, 1311, A, and whereas responsible corporate officer declares it an unlawful act for any state or political subdivision thereon or interstate agency to not adopt and enforce the most strict effluent limitations or other limitations under United States Code Title 33, Chapter 26, 1311, and 1312. And whereas responsible corporate officer declares it an unlawful act for any state or political subdivision thereon or interstate agency to not adopt and enforce the most strict standard of performance under United States Code Title 33, Chapter 26, 1316, and whereas responsible corporate officer declares it an unlawful act for any state or political subdivision thereon or interstate agency to not adopt and enforce the most strict prohibition, effluent standard, a pre-treatment standard under United States Code Title 33, Chapter 26, 1317, and whereas responsible corporate officer declares it an unlawful act for any state or political subdivision thereon or interstate agency to not adopt and enforce a permit or condition thereof issued under United States Code Title 33, Chapter 26, 1342, and whereas responsible corporate officer does hereby recognize President Donald J. Trump's uniform NPDES standards of performance, uniform effluent limitation guidelines, uniform categorical pre-treatment standards, and uniform water control standards in effect under United States Code Title 42, Chapter 55, National Environmental Policy Act, United States Code Title 33, Chapter 26, Water Pollution Prevention and Control, the United States Code Title 42, the Public Health and Welfare Chapter 133, Pollution Prevention. As such, most strict water quality standards, i.e. uniform water quality standards, providing the greatest degree of effluent limitation and other limitations, effluent standard prohibitions, pre-treatment standards and standards of performance respecting discharge of multimedia, human organ at source of pollutants, in the interest of public health and welfare, the preservation of states' waters, water quality, and aquatic life, and for mitigation of human organ toxic pollutants, discharges into such states' waters, and man-made, man-induced organ greenhouse gas emissions. Now, therefore, the responsible corporate officer, in accordance with authority vested in him, her, by the people of the United States of America, the Republic, the Constitution for the United States, International Admiralty Maritime Law, as defined under United States Code, and in compliance with the requirements under God's Word, nature's law, natural law, international law, federal common law, state and federal laws, and in the interest of public health and general welfare and international security of our unalienable guaranteed liberty, the people's right to clean water, clean food, clean air, clean government, and clean earth, and as the caretaker of such resources and the aquatic life, the below defined governing authorities of the United States of America hereby declare their adoption and their commitment to enforcement of President Donald J. Trump's uniform MPDES standards of performance, uniform effluent limitation guidelines, uniform categorical pre-treatment standards, and uniform water quality standards, a water quality standard more strict than the United States Environmental Protection Agency national drinking water standards and regulations, effective immediately. Hey, Sea Whale, welcome. Welcome. All right, this is page 404. It is hereby declared by responsible corporate officer pursuant to this resolution that all branches, public health agencies, environmental protection, and permitting agencies, to include all building and planning and public works, departments of said state and political subdivisions, and interstate agencies shall take the following emergency action pursuant to strict mandatory requirements as defined under United States Code Title 33, Chapter 26, implementation of President Donald J. Trump's uniform NPDES standards of performance, uniform effluent limitation guidelines, uniform categorical pretreatment standards, and uniform water quality standards. The new water quality standards established pursuant to the United States Congressional Declaration of Purpose defined under United States Code Title 33, Chapter 26, 1281, as follows. Every state and political subdivision and interstate body as authorized under United States Code Title 33, Chapter 26, 1319A, subject enforcement, compliance orders, and pursuant to requirements under United States Code Title 33, Chapter 26, 1313, shall immediately promulgate as full faith and credit their adoption and commitment to the enforcement of the new uniform water quality standards by 1, all state governors, 2, all secretaries of state, 3, all water pollution control agencies, and 4, all states and interstate agencies of states bordering drinking water resources. 2, every state and political subdivision and interstate agency, as expediently and practicable, shall enter into contracts with private agencies, institutions, organizations, or individuals qualified to implement the new uniform water quality standards. Every political subdivision and interstate agency operating within above defined municipality and county agrees to immediately notify all septic tank manufacturers within their respective jurisdictions to cease manufacturing of septic tank and to begin producing tankage suitable for implementation of the best available demonstrated control technology that shall be specified for the brand name Reclamator or equal to meet and produce the new uniform water quality standards required at all sources of man-made, man-induced pollution as mandated by law. It is further directed by responsible corporate officer as expedited and practicable that widespread publicity and notice be given of this resolution to all governing county officials and to all officials of municipal political subdivisions and all interstate corporate bodies for their immediate adoption and commitment to enforce the new uniform water quality standards pursuant to the United States Code Title 33, Chapter 26, 1370, state authority, or be construed as impairing or in any manner affecting any right or jurisdiction of the United States with respect to the waters, including boundary waters of such states, and that the environmental court is a district court of the people established by act of the United States Congress assembled on October 18, 1972. Section 9, Public Law 92-500, Federal Water Pollution Control Act amendments of 1972. And as such, a court established by act of Congress may issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the urges and principles of law as confirmed by Judicial Act of 1789 as amended and codified under United States Code Title 28, 1651A, and that the Environmental Court was commissioned by the sovereign body politics of the people of the United States of America on July 11th, 2013, and further that the International Environmental Court is a high court having original and final jurisdiction on all environmental matters. Immunity. Section 2, Section 505A, Citizen Suits, assures that persons who take action to adopt and enforce this resolution in support of environmental justice to promote the general welfare for the common good of the people qualify for a conditional immunity against retaliation by the deep state stakeholders to the extent provided under the People's Bill of Rights Amendment, Article 11. That would be Article X1, I believe that 11. By a responsible corporate officer, that's where they would sign, and then jurate for their signature. That's where they would sign and facilitate this. Now, we also have here an environmental court for environmental district court, uniform writ of execution. Now, this one would be basically the same thing that I read earlier, but this does not come. This one I don't believe comes with the resolution. You see, we have 4. So there are, let's see, what exactly do we have here? It's basically the same thing. So I'm not going to read those over. And then Buffalo Water Authority. So this is from EWG Tap Water Database and utility details. Buffalo, New York serves 267,000. Data available 2014 to 2019. Well, they haven't checked in a while. Surface water. Source, surface water. Contaminants detected. 11 exceed EWG health guidelines. 22 total contaminants. So, well, I can't even pronounce this, I don't think. Bromidochloromethane, 147 times the EGW's health guideline. Chloroform, 39 times the EWG. Chromium, looks like 35 times. The bromic acid, looks like 51 times. dibromochloramethane, 38 times. Dichloric acid, 37 times. I can't pronounce these things, 154 times. 372 times. 2.4 times, 188 times, 71 times. These are all toxins, cancer-causing toxins. We got 1,800 Americans dropping dead every day because of the toxic water that we're drinking. How about that, people? So, every one of you is born an agent. The People's Bureau of Investigation is your resource, is your tools. The People's Bureau of Investigation does not represent you. The People's Bureau of Investigation is you. You can be a process server for the environmental court. The People's Bureau of Investigation website and Telegram channel have the tools for you to be a process server. Every service is eligible, is not eligible. Every service has an award of $2,000. You serve 10 tyrants a day. What is that? That's $20,000 a day, isn't it? Arrest of one of these tyrants, $10,000. If it's a bar member, $20,000. If you watch my Own Your Authority 6 YouTube video, there's a link in there to an eighth grade test. A lot of people said, oh, I only got an eighth grade education back in the day, right? Try and pass that eighth grade test. I'm going to bet you can't. And when you realize the level of education that an eighth grader had in the late 1800s, and when you listen to that talk and you realize that the American Bar Association was formed in the late 1800s, and one of their primary objectives was setting the academic standards, well, you can see they've done a really good job at dumbing us down generation after generation. Well, they hide everything from us, infiltrate our country in every capacity, enslaving us, poisoning us, and murdering us, trafficking us, and, well, we're not so dumbed down anymore, are we? No, we're not. Now, they've been emasculating the male population because eliminating the alpha male is one of their means of taking control. So this is where you men got to put a spine in your back. Now, for all you women who are dealing with spineless males, go out and get yourself a water electrolyzer and a water tester. Draw off your tap water and put that electrolyzer in there, put that water tester in there, and show your man. And then say, honey, is this acceptable to you? Now, if he's a man from 2020, 2021, 2022, you got a real high percentage, he just spending all his time hiding, let somebody else know. All right, honey. You show him. I didn't mean any offense. Ladies, you show him. Show your man. And you ask him, is this acceptable to you? Ladies, you got all the power. If mama not happy, nobody's happy. They're murdering us, all of us. Your brothers, your sisters, your children, your grandchildren, your mom, your dad, your friends, everybody. They've enslaved us. They've got us living in fear. They got us so dumbed down, so confused, so poisoned. Everybody's trying to figure out what to do. Well, we figured it out. The bar hid the law from us. The bar hid the courts from us. The Environmental Protection Agency crucified and shut down the man who invented the technology to give us pure, potable, healthy, healing water. So it's time to wake up. It's time to stand up. What I just read to you is available on the services page of the website oralhealthwithcannabis.com, where you can learn about how government has done nothing but attack me from the highest capacities internationally. The United States government internationally interfered. They've oppressed this and attacked me just to keep you sick. The same way they did to Tom with his reclamator and his patents, just to keep you sick. The sicker you are, the weaker you are, and the sooner you die, the happier they are. And we're not very happy about it. So anybody got any questions? I'll take a look. I'll put my eyes on, take a look at the comments here. Let's see. Yeah, what these filters just don't do it. In addition to your filters, you're probably going to want yourself a distiller. Shower mate. I'll tell you, you're bathing in toxic water. You're bathing in sewage, toxic sewage. You're cooking with it. You're washing your dishes with it. You're drinking it. You're rinsing off your vegetables. You go get your vegetables and you want to rinse off the stuff they spray on there, those toxins and antifungal stuff. And what are you doing? You're rinsing it off with sewage. Yeah, I opened up a can of chicken the other day. I'm draining off the water thinking, oh man, how many years has this been marinating in sewage? What's your favorite canned food? Marinated in sewage. Good golly, people. It's time to own your authority. So, again, the links are in the description. The People's Bureau of Investigation on Telegram has nightly question and answer on Sunday, Tuesday, and Thursday, 8 p.m. Eastern, 7 p.m. Central Time. Come on over. Join the Telegram channel and read the welcome post. The welcome post will get you started on how to go through the process. All right? We're going to own it, folks. We're going to clean up. We're going to take down this evil tyranny, these parasitic communist bar agents. We're coming. All right, everybody. That's all I got for now. Much love. I'll be back soon. I got to give I'm going to give you an update on what the United States Postal Service is up to. I haven't quite figured out exactly how I'm going to deal with it yet, but you can be assured Moabs are most likely involved. All right, Moabs, mother of all bombs. That's what we're talking about here. All right, everybody. I love you. Be good, be safe. Learn your power, own your authority.